everyone, my name is Geetanjali Singh and I am interning at LEXIS and Company, and the topic for today's video is analysis of Article 32 of Indian Constitution. Now we all know that the Supreme Court is the major factor that represents justice and injustice in our country. Similarly, Article 32, which is the spirit of the Constitution and exceptionally the heart of it, is the main fundamental right that protects and safeguards the Indians' fundamental rights and procures justice. Now, in this video, we must learn what is Article 32 and the types of writs that has been given under, and the Supreme Court, how it issues the writs, and in this video we learn about two types of writ, and rest of them, that are prohibition, certiorari and quo warranto, we learn about it in next video and the conclusion part of it. Now let us start with this video. We must learn what is right to constitutional remedy. Now as we all knows that Article 32 is also known as the spirit of the constitutional and exceptionally the heart of it. By Dr. Ambedkar, he said the preeminent court has included in its fundamental structure regulation. Further, it is being clarified that privilege to move to Supreme Court can't be suspended without the exception of generally given in this Constitution. This suggests that this privilege suspended amid a national crisis under Article 359 was also not valid. Article 32 makes the Supreme Court the safeguard and underwriter of the major rights. Furthermore, the capacity to issue writs goes under the original jurisdiction of the apex court. This implies an individual may approach Supreme Court straightforwardly for a cure as opposed to the appeal. Article 32 can also be used to get a remedy for fundamental rights enshrined in Article 12 to 35. It isn't there for some other legal rights for which diverse laws are accessible, but to protect and safeguard our fundamental rights and major rights. Now, what are writs? We must learn that writs are a written order from the Supreme Court or a High Court that commands constitutional remedies for Indian citizens against the violation of their fundamental rights. Article 32 in the Indian Constitution deals with the constitutional remedies that an Indian can seek from Supreme Court and High Court against the violation of his or her fundamental rights. Article 32 under Supreme Court and Article 226 we can file for an writ under Article 22 of High Court. Now there are five under Article 32 is a basic right that directly falls under Part 3rd of the Constitution, and under this right the Supreme Court is enabled to loosen up the customary standards of locus standi and permit social to intrigue case in the name of PIL, public interest litigation. Now there are five kind of writs. Number one is habeas corpus, second is mandamus, prohibition, certiorari and quo warranto. For the fact first, we must learn what is habeas corpus, the most famous writs of all time. This is a Latin word, habeas corpus, which means to have a body of it. This writ is used to enforce the fundamental right of an individual liberty against any unlawful detention. Through habeas corpus, the Supreme Court or High Court can order one person who has arrested another person to bring the body of the latter before the court. Now, facts about his habeas corpus in India is that Supreme Court or High Court can issue against both private and public authorities, and in the case of Rudul Shah versus State of Bihar, it added a new dimension to judicial activism and raised a set of vital questions such as liability of state to compensate for unlawful detention, feasibility of claiming compensation from the state under Article 32 for wrongful deprivation of fundamental rights, propriety of the Supreme Court passing an order for compensation on habeas corpus petition for enforcing the right of personal liberty. Now, facts, habeas corpus cannot be issued in the following cases: when the detention is lawful and when the proceeding is for contempt of legislature of a court, or when the detention is given by the competent court and the detention is outside the jurisdiction of the court. The famous case of and the landmark case of ADM Jabalpur versus Shivkam Shukla, which is also known as the habeas corpus case, it was held that writ of habeas corpus cannot be suspended even during the emergency under Article 359. It was given as an implication of emergency that where every fundamental rights were suspended of every individual. But this writ cannot be suspended in that case also, and this can be issued when the detention is illegal and the detention is not given by the competent court. Now, moving further, we must learn what is mandamus. The literal meaning of mandamus of the writ is that we command. This is the writ used by the court to order the public official who has failed to perform his duty or refused to do his duty to resume his work. Now, besides public official, mandamus can also be issued against any public body, a corporation, an inferior court, or a tribunal, or a government for the same purpose. There is a rule called locus standi, which is strictly followed in while issuing the writ of mandamus. In this, the petitioner has to prove that he has the right to enforce a public duty in his favor. The mandamus is neither a writ of course nor a writ of right, but it will be granted if the duty is in nature of a public duty and it especially affects the right of an individual provided there is no more appropriate remedy. There are some necessary conditions to issue the writ of mandamus, in which is error of jurisdiction and the jurisdictional facts of it are not given, violation of the principle of natural justice, that is audi alterum partem, or rule of biasness, or error of law apparent on the face of record, that is, and any abuse of jurisdiction. In the following case of Praga Tools Corporation versus CV Emmanuel and Sohan Lal versus Union of India, the Supreme Court stated that mandamus might, under certain circumstances, lies against a private individual if it is established that he has colluded with the public authority. Now, some rare facts about mandamus in India is, unlike habeas corpus, mandamus cannot be issued against a private individual, but in certain cases we have seen it. Mandamus cannot be issued in the following cases, where to enforce a departmental instruction that does not possess a statutory force, or to order someone to work when the kind of work is discretionary and arbitrary and not mandatory, and to enforce a contractual obligation, and against any Chief Justice of High Court acting in any judicial capacity, and at the last, mandamus cannot be issued against the Indian president or state governments. That's all. Thank you, and we learn about prohibition, sorcery, and quo warranto in the next video while concluding that. Thank you.